Good morning. This is Pat O'Connell. I'm calling to order the New Mexico Public Regulation Commission's regular open meeting. It's Thursday, January 23rd, 10 in the morning. We're here in the Bochum building. We're also streaming online because it is the day of a New Mexico Public Regulation Commission open meeting in January. It has snowed. So I don't know how we make that happen, but got an impressive record. So it's continuing. Okay, so just to kick this meeting off, Mr. Cameron, can you call the roll?
Commissioner Nybert,
I am here.
Commissioner O'Connell,
Here.
Commissioner Aguilera.
Here.
All commissioners are here. Do you have a quorum, Mr. Chair?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, as the symbol of perfect friendship among united cultures. Commissioners, we have an agenda in front of us. Do you want to proceed with the agenda that got posted, or do we need to make some changes?
I do not have any changes to suggest, Chairman.
Okay, seeing no changes to the agenda, we will proceed with the agenda that was posted. Is there anyone here that would like to provide a public comment? Not seeing anybody in the room. Mr. Rodriguez, has anyone registered to give public comment on Zoom?
Mr. Chair, there's no one online for public comment.
Great, thank you. Moving along, next is announcements. Office of General Counsel, do we have anything?
No, Mr. Chair, thank you.
Commissioners, I just have one announced hearing between now and our next public meeting on February 3rd at 9 a.m. There's going to be a hearing in case number 24-00250 UT. That case is a establishment of a service barrier or boundary between SPS and Farmers Electric Co-op. So kind of an interesting case, doesn't happen very often. That is scheduled to commence at 9 a.m. If you're interested in that, go to the webpage to figure out how you can watch it. And then as always, it'll give you instructions on any comments you might want to provide. Commissioners, did you have any other announcements?
Thank you, Mr. Chair. Tuesday, the legislature began and I did have several discussions with some of the legislators who will be considering some of the issues that we are advancing. And so I can tell you that I received some favorable feedback, and I think that we may be able to get some things done favorably for this commission in this legislature. So thank you for the opportunity.
Yeah, that's good to hear.
Nothing further from me. Thank you.
Okay, so next up is prior meeting minutes. We had two sets of minutes in our package for today's meeting. I made a acronym edit for the December 12th minutes and didn't see any changes for December 19th. So commissioners, did you have any changes you wanted to see on those minutes?
No changes for me, Chair.
Okay, so seeing none, I will move for approval of the December 12th at 2024 and December 19th, 2024 regular open meeting minutes.
Second.
Mr. Cameron?
Commissioner Nybert,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
Aye.
The motion to approve the minutes for the December 12th, 2024 regular open meeting and the minutes for December 19th, 2024 regular open meeting passes unanimously, Mr. Chair.
Great, thank you. Next up is the consent action item. We have a consent agenda with 8 items on it. Is there any discussion or questions for OGC on the proposed orders on consent action items? Seeing none, we can proceed. I will move for adoption of the potential orders on the consent action.
Second.
Any discussion before we vote? Seeing none, Mr. Cameron.
Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
Aye.
The motion to approve the consent action items passes unanimously, Mr. Chair.
Great, thank you. All right, so now we are in regular action items. First up is Mr. Fisk with two cases. We'll start with the notice of proposed rulemaking to the State Rural Universal Service Fund. Take it away, Mr. Fisk.
Good morning, Mr. Chairman and Commissioners. As the proposed order issuing notice of proposed rulemaking indicates, and then the caption itself indicates, this rulemaking would be to conform the Commission's State Rural Universal Service Fund, or SRUSF, rule to amendments to the Rural Telecommunications Act of New Mexico, which is the act that created the SRUSF and gives the commission authority over it. There were some amendments that were made in 2003 that this would incorporate. I've included as Exhibit A the amendments, and then as Exhibit B the proposed changes to the rule. Of course, this would just be proposed rule that goes out there that would be it'd be available to the public. It would be, the public would be notified via the NOPR, as always. That's Exhibit C. And we received comments limited to the topic of changes to the SRUSF for the purpose of conforming to the 2023 legislation. Now, that said, I actually would like to make a small change to this because Kai called me this morning and he pointed something out. He asked me a question about, if you go to Exhibit B, if you have it, I can just describe it. So one of these changes I actually made to just to clarify is something that could have been in the previous version of the rule. It's not really a change that has to do with 2023 legislation. It's just something that while I was going through the rule, I thought, oh, we shouldn't have this. So in Exhibit B, if you go to the broadband program provision or the excerpts therefrom, there's 31A, then there's 31B. And the last sentence there is in the current version of the rule. To the extent a year's broadband program funding is not exhausted by grants awarded during that year, the funds will roll over to the following year. And I think it'd be better to remove that, not because of the new legislation, just because I think it's confusing. And the reason why is because under the RTA, the Rural Telecom Act, we're limited to a $30 million cap each year. That's an annual cap. And so, like, for instance, last year, we didn't have enough applications and we didn't award all the funding right up to the cap. But those funds don't roll over to this year in the sense that if the commission received many applications this year and wanted to award more than above the $30 million cap, we couldn't. And this line somewhat suggests that we could. I think that when we put this in, we were thinking of the other side of the ledger. The other side of the ledger is the cash. And we do, our fund administrator maintains cash accounts. And to the extent that a big balance builds up in those accounts, then the way that gets balanced is that the next year's surcharge is smaller, but it doesn't affect the amount of money that's available. We stick with the 30 million every year. So I think this is true in a sense, but in another sense, it's not. And so I think just removing this line altogether would be helpful. And the only thing I'd want to change is to say in the order, to just drop a footnote, and also say in the NOPR that there is this one change that isn't about the 2023 legislation, just to make that clear. And with that, I'll take any questions.
Thank you for that presentation and then just grounding, again, this is a proposal to begin a NOPR, so I understand the edit you just described. Next step will be comments from others on the draft, and so additional changes may result before the rules finalized.
Yes, that is correct.
Commissioners, did you have any questions or comments on the draft?
Mr. Chair, I did have one question. On page 5, the sentence, the last sentence of the carryover paragraph, the last two sentences of the carryover paragraph. Public comment by parties to an adjudication pending before the commission shall not be permitted where the comment concerns substantive matters at issue in such proceeding. And then it talks about a court reporter. My concern is, Mr. Fisk, is whether or not we've looked at whether that might violate the First Amendment rights of any public member who wants to provide comment in a rulemaking proceeding. Because we are limiting the subject matter that they could bring forward in a rulemaking proceeding outside of their, the matter that's being adjudicated.
Commissioner, no, we have not looked into that question as far as I know. I certainly haven't myself. That's something that we can look into. There is, as part of the law that pertains to the commission, the Public Regulation Commission Act, I believe. There's a prohibition against ex parte communications. So if a party is a party, someone's a party to an adjudication, and that adjudication is pending, then the commission is supposed to avoid having discussions with that person. And in a public comment hearing, at least about the adjudication. Now, that same person could make a comment about the rulemaking, as long as it doesn't touch upon the adjudication that's pending at the same time.
Well, my thought process is if the rulemaking concerns the same subject matter, that they are involved in an adjudicatory matter, we would be prohibiting them from making public comment on certain issues. And I'm not sure that the First Amendment would allow us to constrain them. Now, obviously, they can't make ex parte communications, but this is a public meeting and they're making public comment with respect to the rulemaking. I think all parties should realize they can't argue their case, use the rulemaking process to argue their case, but I'm not sure you have an ex parte communication in a public meeting on a rulemaking, even though they're talking about the same subject matter that may be related to the adjudicatory issues pending before this commission. So I think we probably ought to look at that a little bit and make sure that we are not creating a rule that would then be struck down for denying people their First Amendment rights. Thank you, Mr. Chair.
Thank you, Commissioner.
Any other questions, comments?
Well, we do have to, or I believe we should rather, try to issue an order today. In the spirit of doing that, Commissioner, would you feel comfortable if it said that public comment by parties to adjudication pending before the commission shall not be considered evidence in such proceeding? And maybe, I think maybe that's what the intention is here. I agree with you that they should be able to, say whatever they want about it.
Mr. Chair, may I respond?
Yeah, we're pretty informal here, so.
I don't need your, okay.
Fly.
I usually get slapped down for not,
There's only three of us and hopefully,
I'll get used to the procedure.
yeah.
Yeah, I think, certainly that would be, that's definitely the case, because the only evidence that would be considered in an adjudicatory matter would be the matters that are brought up in that adjudication proceeding. And I'm wondering if the sentence even needs to be there, frankly.
I think eliminating it would be fine too.
Yeah, because, you know, if a party, I would foresee that we do have rulemaking that touches on issues that are subject to proceedings before the commission. And I would think that in the rulemaking process, we would welcome comments by the regular parties who appear before us, because they're the ones generally affected by it. And so we would welcome their comments with respect to the rulemaking. But I think those statements would never be used, could not be used, and probably would not even be considered with respect to what goes on with the hearing examiner, with respect to the general counsel's office, and respect to this commission when it comes to adjudicating a specific matter that's before us. I really see that as being somewhat distinct. You know, revising it or eliminating it, I could go with either, but before we get a final rule, I think that issue needs to be fleshed out. But I'd be comfortable with eliminating that sentence.
And Commissioner, that's fine. I'm sorry, could I get clarification? I don't know exactly where we're looking. Are we in the order itself?
Yeah, it's order issuing no per page 5 of 6, paragraph H. And second to last sentence in paragraph H.
Oh, thank you. Thank you very much. It would be okay with me to remove that. That'd be fine with me. Scott?
Yeah, I don't see any issue with that. And I was just looking for the language around public comments aren't considered as evidence. I know that when we get a little farther into the proceeding and we put out the actual NOPR, that appears in there, and that is in our rules. And so you know, I think either just taking it out altogether or changing it, either way works. So
Okay, yeah, I mean, it seems like it would be easier to eliminate that. On the issue that you presented on, Mr. Fisk, the last sentence that is being revised, but not directly as a result of the legislature's changes. You mentioned explaining this additional change in a footnote. I would just ask that maybe it be in the body, just so that it's instead of a footnote, so that it's more prominent in the order.
Okay, I'll do that in the body of the order, and I'll also do it in a paragraph, a short paragraph in the NOPR, just to point that out.
Any other discussion, comments? I listened to the changes on this public comment, and I agree we should be, for me, just expansive in the invitation for public comment. So not just First Amendment rights, but best practices. So Mr. Fisk, do you have any questions? You've received 2 changes, and you understand them both?
Yes, I do. Thank you.
So then I'll move the adoption of the order you proposed with the edits we've agreed to here.
Second,
Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilar.
aye.
The motion to approve the order with the edits just discussed passes unanimously, Mr. Chair.
Thank you. Thank you, Mr. Fisk, and you also have the next one, another the adoption of interconnection rule applicable to rural electric co-ops.
Yes, thank you, Mr. Chairman, Commissioners. So my proposed order would open up a new rulemaking proceeding to consider adopting an interconnection rule applicable only to rural co-ops. In docket 2381 UT, which is one of the dockets in which, as you will recall, there were variances from the amended interconnection rule. I believe it was amended in 2023, I believe. That were made that some of the investor-owned utilities and many of the co-ops asked for variances from certain portions of the sort of technical upgrades that were required by that rule. And the commission has granted a number of variances. Last fall, the rural co-ops, most all of them, not all of them, but most all of them, I believe. It may actually be all of them. Requested, they petitioned for an extension of their variances to certain parts of the rule. And they noted that they would like to, that they had been discussing among themselves and with staff of the commission, a potential rule, a separate interconnection rule that would apply only to rural co-ops. So it wouldn't be so that they wouldn't have to request variances from the rule that applies to IOUs. And so the commission ordered the co-ops to file a petition with their proposed rule, and they did that. And this would take that petition, start a rulemaking in a new docket, and take administrative notice of that petition because it's from another docket, and would ask staff first to respond. Staff was involved in some of the discussions, but I don't know that this is a proposal that staff fully agrees to. So we'll see that, and we'll also get responses from anybody else who wants to respond to the petition on or before February 24th. Thought we should give them plenty of time. That way we'll have a good written record. This won't be we're not in the formal comment. We're not in the formal process yet. This will still be the informal process. So the commissioners could speak freely and I could speak freely with people who comment at this point. Of course, we can do that during the formal comment period too until the record closes. But this would just be to get this started. They asked for a workshop. There wouldn't be one that would be scheduled in this order, but there would be because I think first we want to see what we get in terms of responses, and then we'll know, of course, who to notify about any workshop as well. And with that, I'll take any questions.
Yeah, thank you for bringing this forward. We've had over the last couple of years, quite a few discussions on interconnection rule, and I guess just summary landing place for me is the co-ops are different, especially on this particular item. Their incentives for distribution system investment are different. There's a wide range of ability within co-op world of each co-op to handle the technical issues that interconnection produces. So broadly, I agree that it's good to have a different rule on interconnection for co-ops than we have for the IOU. So looking forward to this rulemaking on that dimension. Having said that, is there any questions or comments on what's proposed? Again, this is a launching the ship exercise. It's not the ship. So.
Thank you, Chairman. I just want to note that the idea to conduct these workshops is a request from the joint petitioners.
Yes.
So I wanted to note that and also comment on that I appreciate the co-op's efforts here to create a rule that they can comply with and that will move this issue forward. So that is all. Thank you.
Any further discussion or a motion?
Mr. Chairman, I move that we adopt the initial order in this case and allow the rulemaking process to proceed.
I'll second that. Any further questions before we vote? Mr. Cameron.
Commissioner Aguilera,
I,
Commissioner O'Connell,
Aye.
Commissioner Nyberg.
Yes.
The motion to approve the order as written passes unanimously, Mr. Chair.
And thank you, Mr. Fitz.
Thank you, Mr. Chairman, Commissioners.
Okay, so now we have two cases that are being managed by Miss Alyssa Herrera Waldrop. First is 24-00238 UT, which is PNM's application for continuation of a plan to manage fuel and purchase power costs by entering into certain forward market transactions. Lots of words for hedging. Take it away.
Thank you, Chair. And I turned on the microphone this time. Good morning, Commissioners. This matter concerns PNM's application for reauthorization of its hedging plan. PNM filed its application earlier this year, seeking the reauthorization of its plan through 2029. The application requested that the costs and benefits of the plan continue to flow to customers through the FPPCAC and the guidelines for the hedging transactions to continue without modification. No party intervened and staff provided testimony which proposed some modifications to the application and recommended approval of the application. The recommended decision recommends approval of PNM's application subject to the modifications proposed by staff and with some additional suggestions to ensure future reapprovals of the hedging plan are meaningful. No party filed exceptions to the recommended decision. What is before the Commission today is two orders, both which adopt the recommended decision in full and provide some additional clarity regarding the steps PNM must follow when future market purchases fall outside the approved guidelines. And I would like to go ahead and briefly summarize the recommended decision and the proposed final orders unless there's any questions right now. Okay. So, as for the recommended decision, as a general matter, there was relatively limited disagreement about whether the Commission should approve PNM's application. Staff did propose the 6 modifications to the hedging plan, in which PNM only disputed 2 of them, and those proposed modifications were related to resource adequacy transactions. The recommended decision found that staff had the better argument and that hedging transactions, including resource adequacy transactions, should be included in the calculations of the guidelines in PNM's annual report, regardless of the transaction's intended purpose. The recommended decision also found that the guidelines proposed by PNM were reasonable and appropriate. These guidelines are not mandatory as PNM, provided there may be situations in which it must depart from its own guidelines. The recommended decision did suggest, however, that for future reapprovals, PNM should provide testimony to the Commission as to whether there's a need for modifications to its hedging guidelines, as the guidelines have remained the same throughout the past 15 years since the application's first approval. Ultimately, though, the recommended decision recommended approval of the plan subject to the staff's proposed modifications and the hearing examiner's additional considerations for future reapprovals. Moving on to these proposed final orders, the first final order approves the application and adopts the recommended decision in full. The final order also takes the opportunity to clarify that PNM must follow the process established in the recommended decision for future market purchases outside of the approved guidelines. And the second final order adopts all that the first final order does, but adds an additional filing requirement. That is, PNM must file the reauthorization of the hedging plan no later than 1 year of its operation in the extended day ahead market, or EDAM, if that deadline occurs before the deadline provided by the recommended decision. So before we kind of move on and discuss the filing requirements, I do want to flag an issue that I've spoken with some of you individually about regarding the inclusion of these resource adequacy purchases in the hedging guidelines calculation and modification of the reporting requirements by not including the opportunity gain or loss from each of those transactions. The recommended decision includes these resource adequacy transactions in the guidelines and reporting requirements, which the final orders as drafted adopt. And I wanted to open the floor to the commissioners to discuss this subject. And Commissioner Nyberg, I don't know if you wanted to go ahead and start the conversation, and I'd be happy to facilitate the best I can.
Mr. Chair, I certainly, in reading the materials and then having a fairly lengthy discussion yesterday, and I appreciate the time that you took and the hearing examiner took with me. I did find some merit in PNM's argument that the resource adequacy transactions should be viewed maybe a little differently than their other hedging activities. And what I analogized it to was basically if I individually wish to participate in what I consider gambling in the commodities market, I can buy and sell corn thinking the price will go up or down, and I reap the rewards or take the loss based on my decision. And I have no use for that corn. If, on the other hand, I am in the business of milling corn into flour, and I buy corn at a set price on day one with anticipated delivery on day 100, I'm just paying in advance for that product. I know I'm going to need that product. I know I need it to operate my business. So there's an entirely different purpose that I see is important. And I don't think the electricity market's any different, or frankly, the gas market. They're going to use that resource to meet their expected load on day 100. They're buying in advance that energy on the market at a price that is certain. And I think that certainty gives the customers of PNM in this case some benefit, even though on day 100, because of market conditions, maybe it's 70 degrees outside across the country, nobody's got their air conditioner running, the price of gas or electricity on that specific day is lower than the price that they bargained for 100 days earlier. Is that really a loss? And should it be reported as a loss? They just purchased in advance. And so I see that as a different circumstance, different in a different light than the other hedging that is occurring, and that is trying to anticipate other loads that they may or may not normally expect. So for the meeting their regular demand and trying to accommodate a program that allows them to purchase in advance at a set price that energy in the open market makes tremendous sense to me, and apparently is working. I think the testimony is that the program is generally working. But having to report those numbers in the same fashion as their other hedging numbers can lead to some issues, not only for the company, but I think for this commission when you report huge losses. And I question whether it's a huge loss or not, if you're just advance purchasing that power. So frankly, what I would advocate for is that PNM report both. They report their hedging gains or losses for their resource adequacy needs, their normal electrical needs for that day or for that month, whatever, separately from the resources that they're locking up or purchasing to take advantage of market conditions and what I consider gambling. And so I would advocate that they report them, but they report them separately and that we deal with the resource adequacy transactions in a different light, which is a little bit different than what staff recommended, maybe a little bit different than what P&M recommended. But if we don't do that, then if they guessed right, we're gonna show huge gains. If they guessed wrong, they're gonna show huge losses when, in my mind, they're just buying that product that they know they're gonna use on day 100 at a set price. And there's some value in that. And that even though the market may show a higher or lower price on day 100, that's somewhat irrelevant to me, and showing a huge loss because on day 100 the electricity price is at rock bottom, or it's the other way, sky high. They shouldn't be shown to be the hero or the villain in either case, and for the resource adequacy. For the other stuff, they're rolling the dice, and they're rolling the dice with the consumer's money, and that may need to be highlighted, and this commission needs to know that. So that's kind of my thought process on that. And I'm not familiar enough with the process to recommend anything, but it seems to me that the order should be approved, but allow the necessary changes to deal with maybe a future order that deals specifically with the resource adequacy transactions and deal with those separately. I may have messed that up. Please correct me if I'm wrong, but that was kind of my thought process when I read that in the testimony.
Yeah, thanks for that. I took a particular interest in this case when I saw the application. What P&M was asking for was approval of a hedging plan that is embodied in this set of guidelines that they first asked for in 2009. And then just routinely have asked for approval of these guidelines for 15 years. And the guidelines have not changed in 15 years. And so that my brain immediately went to the old foolish consistency is a hobgoblin of little minds, right? So how can these guidelines still be valid when they were established in 2009? And the world is very, very different than it was in 2009. So digging into it, what I saw was kind of a misalignment in what P&M was doing versus why they said they were doing it. You know, I agree, the testimony in the case really shows that customers benefit from P&M participating in the forward markets, whether it's for reliability purposes or whether it's for the hedging activities. And the goal of the hedging isn't to take advantage of market conditions. It is reduce price volatility in the FPCAC. So that's just, you're trading unknown for an unknown. And the belief is less volatile is always better than more volatile. So that I question. I'm not sure protecting customers from price volatility is really a desired outcome. Especially if you look at what's gone on with energy prices over the last few years. I mean, they were paying you to take gas in the Permian last year. So the hedging program prevented P&M's customers from benefiting from that. So it's not about taking advantage of market conditions. Price volatility isn't a great reason. I was convinced that just them participating in the future market and taking positions then created a backbone of flexibility. So as things change, they're in a better position to deal with the changes. So they were asking for something they haven't thought about for 15 years. They gave us the wrong reason for why we should approve this thing again now for the next 5 to make it a 20-year guideline that have never changed. So, and then the application was lazy. I mean, they included they were just repeating testimony that they've filed over these 15 years. They throw in a Henry Hub price curve and like, do you buy gas at Henry Hub? No, we don't. So why are you giving me that piece of information? So this case is one where I've got to give credit to staff, the testimony provided by utility division staff saved PNM's application. The hearing examiners, and frankly, one of them is one of our new ones, John Kreinkamp. He got faced with me asking him questions, this bad application from PNM, staff providing testimony based on the application, nobody asking the bigger picture question of why are you even asking for this thing? And I think he managed that very well. I really commend the recommended decision. I'm the proponent for let's make them file sooner. So I worked through that with Miss Herrera Waldrop. Thank you for that, because my first thing was guns ablazing, just reject it, because they're asking for something for a dumb reason and they didn't even think about it when they filed the application. So working with her got us to this draft final order. Again, because this is just wash, rinse, repeat for 15 years. I wanted to put in there, you're gonna ask again when the next time your world changes significantly. Not sure what the best marker for that was, but they've announced they're gonna join EDAM. That's a different market than what they're participating in now. So anyway, that's why I'm with you. I agree in adopting the recommended decision. I want PNM to thoughtfully refile using the very good guidance provided in the recommended decision when their market changes. If they don't join EDAM in 5 years, then do it again in 5 years. If they do sooner, then do it sooner. And do a better job is really what I'm saying. But because I'm convinced that the activity of hedging, participating in the market, is valuable to customers, I'm in favor of approving the recommended decision. As far as separating reliability purchases from hedging guideline transactions, that to me, I agree with what the recommended decision recommends because of what PNM asked for. So they were saying we're trying to manage volatility in prices. Well, buying power at a fixed price affects volatility of prices, whether you did it for guideline purposes or whether you did it for reliability purposes, you still warped your management of managing price volatility. So that's why I don't have a problem with telling them you got to report any transaction that manages price volatility. That's how I looked at it. It wasn't gamble versus reliability. It was, are you doing what you said you're doing, which is managing volatility? I mean, it was really weird that PNM was saying, oh yeah, those are fixed prices, but they're not hedging, even though definition of hedging was manage price volatility. So PNM put themselves in a weird spot there. And again, staff, hearing examiner, Ms. Herrera Waldrop have helped me get to the point where I'm voting in favor of this, where I started from, this is nuts, let's reject it. So anyway, that's my thoughts.
Well, thank you both for those thoughts. So with respect to the EDAM one, I think I'd like to respond to that, because I think it might be easier, at least for me. I agree that it's a valid basis to require a plan earlier. So one of the orders as proposed would require PNM to seek reapproval 1 year after their participation in EDAM. And it is a significant change, as it'll be affecting the spot price in that transaction. And for the other reasons that the chair explained, and also that I sort of read through the RD, which I agree was very well done. There is a desire to dig deeper into what the guidelines should be. And so I agree with that change, and wanted to suggest one wording change in paragraph 31, it says for this reason, PNM must submit a filing concerning its hedging plan. I think the intent is to submit a filing seeking reapproval. And so when I read that initially, I wasn't sure what it meant. And so I wanted to suggest replacing the word concerning with seeking reapproval of. And to me, then that makes it more clear as to what we're asking them to do. But we could continue to talk about that. As to the resource adequacy versus hedging issue, Commissioner Nybert, I had a similar conversation with our council that I think there is merit to what PNM is explaining. There are distinctions. The reason why I didn't suggest an alternate or changing from the recommended decision is well, there are a couple of reasons. One, I also saw merit in staff's arguments, and I thought that the recommended decision landed on a reasonable outcome. And so that in concert with the fact that PNM did not file exceptions, to me said that they can live with this. And therefore I didn't propose any alternate from there. But I do agree, just generally that there is some distinction between the resource adequacy and the hedging. I see that there are different bases for both of those. And ultimately, couldn't disagree with the RD that it wasn't reasonable. I think it is, and the fact that PNM didn't file the exceptions, I think, is what kind of made me land on just adopting the RD on that issue.
Mr. Chair, the one of the concerns I have is the information that was reported for 2023 and the perception that may prevail as a result of what I consider a tremendous loss that year, $95 million. If 90 of that $95 million loss was simply due to meeting their normal needs, I question whether that should be calculated as a real loss, because they're just buying in advance the energy that they were going to need on that day 100. So the public perception is, look what PNM, they lost all this money, or we're having to pay all this money when we shouldn't have that. Well, because of the load that PNM has, and I guess we can get into a discussion whether they ought to be going on the open market or whether they ought to be generating, but they're obviously going on the open market. But prepaying for that energy, I think, in my opinion, and I think in the recommended decision, the order before us, that makes sense. And it's in the long run saving consumers money and avoiding some of the volatility. And I think if you live close to Texas, you know what the volatility did a few years ago caused lots of problems for people. But having that constant price makes some sense. I just was a little concerned about the public perception, and I have no idea what the real numbers were between what was in that $95 million. I have no idea. But if the majority of that was due to the prepayment of energy they knew they were going to need to meet their normal demand on that day, and to have a number like $95 million out there just causes some reaction from me, and I think most people, because the program is supposed to save the consumers money, but that number shows that they paid more money. And so that's why I don't mind them reporting the number, but having the report separate the two, because there's a different explanation for the one, just made sense to me, but, again, I share both of your concerns on, this program's gone on for, 15 years or so, and, conclusion is it's working, but it's greatly changed. I mean, before P&M could meet its base load, and so these resource adequacy transactions were probably not needed at that time. It was truly hedging when it started. Now it's, at least for a part, and maybe until they get more generation in their system, it's at least a part of it's meeting their normal everyday needs that they know are going to occur on day 1, day 5, day 100, day 365. And I did ask the question, can this commission force them to build more generation, if that makes sense? And apparently there's things in the works there that I'm not familiar with, but that's the dilemma I think P&M's in, is how does it meet its normal needs? And let alone try to figure out how to meet unexpected needs that may result due to inclement weather, may result from additional demands because of economic development opportunities, what have you. And so I don't know how all these people factor all those variables in, but I think that this, at least for now, has some ability to meet that. But reporting that one number concerns me a little bit, because there's no distinction between what are we doing to meet the normal load versus what we're really doing to deal with risks that are unexpected. So that's just kind of my thought process.
Yeah, well, thanks. And one thing I've learned is utilities are listening. So just the fact we had this conversation is of value. The next thing is whatever we ask them to do, they'll do that plus whatever the heck they want to do. So if they've got a reason to distinguish buckets of money, they'll do it whether we ask them to or not. So anyway, that's why I'm not proposing a change to the draft orders we have, other than I agree Commissioner Aguilera's replace concerning with seeking reapproval is a better communication piece. But did you have edits you wanted to make to recommended decision? And then we haven't gotten to, do we want to require a filing sooner than for 2029?
Mr. Chair, on the issue of reapproval, is that just them submitting information, or is that to go through the whole process with a new order from this commission?
It'll be just the same thing that we're looking at right now. It'll just happen sooner than 5 years from now.
And I would add to that the RD also is asking for more testimony and more information. So, I think that would be included in this as well. And so the idea is that instead of filing by June 30, 2028, they would file on the earlier of June 30, 2028, or 1 year after participating in EDIM.
And commissioners, if I can just jump in real quick, Commissioner Nybert, I think a suggestion that staff recommended in terms of the resource adequacy question is also that it should come as a separate exhibit in the annual report with all of the same information. So includes opportunity, gain or loss required of other transactions. So that might quell some concern that we don't know, in the long term, how they're mixing in with these other hedging transactions. So that was a suggestion that staff made and that the hearing examiner did find persuasive and adopt. And so in turn, that is also part of the final order. So there is that. So I just wanted to include that as well. That might make it clearer, how much of the loss that you mentioned were actually these resource adequacy transactions versus other transactions. So it might be clearer in the next annual report as well.
Yeah, and then just to give staff their due, that was one of the things that staff testimony helped me with is, the opportunity gain loss, that's just framing it in the words of how you measure a hedging program. And then using the gambling analogy, if a push is a win, the house always wins, right? So you should expect with hedging that there will be a small opportunity loss every year because the bid ask spread is something you're going to pay, right? So just, there will be just noise around zero if things are normal. The tail risk with energy means that's where your volatility concern kicks in, because if things go haywire, the fact that they hedged is that they'll have years with huge opportunity gains, right? So that's kind of what you expect, I guess, when you look at a hedging program, is small drag every year and then big gain when prices went up. Because you bought the insurance and it paid off really. But so anyway, that's again why I don't have a problem with how we're asking for the information, because it's about managing volatility. I don't care what you did to manage volatility, included in the report. And then they can make the case for this should be viewed differently than that if they feel like they should. But also those reliability transactions they made that year, that was a one-off because pandemic meant resources weren't online when they were supposed to be, but they're online now. So wouldn't expect to see a lot of that going forward. But it'd be worth it to know if there is a lot of that. So that's why, again, willing to entertain any edits you want to suggest, but I'm still liking the RD and the proposed final order.
Mr. Chair and Alyssa, the comments you just made about the report, does that really satisfy my concerns that they're going to report that stuff separately in an exhibit and have those numbers? Is that what's being required, or is that just what we think is going to happen?
So this was a recommendation by staff that the recommended decision adopted, which is in adopting the recommended decision in full is also adopted by the final order. And to kind of point you to the page number 2, this is page 36 and 37 of the recommended decision. In the last paragraph, talks about the suggestions, which is that PNM's annual report should include all hedging transactions in the calculations of its guidelines, regardless of the intended purpose, because PNM's argument was that these resource adequacy transactions did not serve the same purpose, which is reduction in price volatility, as these other hedging transactions. So they shouldn't be included. And staff said, well, they should be included because they're still hedging transactions, but also stated that it could be reported separately as a separate exhibit. So there's still transparency into maybe the difference between these transactions. So it may not quell your concerns completely, but it does kind of address that this is a suggestion. Hearing examiner said, yes, that's a good suggestion. And in adopting the final order that adopts the recommended decision in full, then that would be a requirement. And that's always some language we could include in the order that makes it clearer if that's something that the commissioners would like. But my understanding is in adopting this recommended decision, then that, yes, that is also adopted in the final order, and that is required of PNM to do.
It's well, what's required is that they report it all, but they recommend that they should separate out the stuff. I guess
If they perceive a risk, they will.
if they see that to their benefit, I would argue that those numbers should be very transparent to not only us, but to the public. And they not only should do it, I would say they must do it, but anyway, I'm not gonna, it's not gonna alter my view on that. It's just that I would see that more mandatory than discretionary.
Okay. So do you have an edit you'd like to make?
No.
Okay.
Okay, Commissioner, so to clarify then, in terms of the resource adequacy, the commissioners approve the way that the final draft is written in terms of adopting the recommended decision. I just wanted to clarify. Right, and not completely adopting the final order. I'd still like to clarify the differences between the two orders I proposed. I just wanted to make sure I understood the resource adequacy part. And so Mr. Chair, I know you've already provided
You
some
confused me.
background.
So-
Sorry.
All right, let's back up.
Yeah.
Your draft final order.
I
You're
was-
highlighting a modification to the RD. Is that right?
I apologize. Can you say that again?
What I was hearing is that the draft final order, you're just looking for confirmation that a change to the RD around reliability purchases is what we're agreeing.
Right.
Okay, can
Okay.
you point to that paragraph in the final?
Or was the
Okay.
change the E EDAM?
I apologize.
Yeah.
I want to make sure. So the discussion we just had involving resource adequacy, that's not highlighted in these final orders.
Yeah, I didn't.
I see.
That's
Okay.
where I got
Sorry.
confused.
I was making sure I understood. But because this came up in discussions after I've provided these, I wanted to make sure we had that discussion, but it sounds like we're not changing anything in terms of resource adequacy. And now we can move on to the two orders as written. Aside from Commissioner Aguilera's change in the wording, because that would, I think, go into either one. And the first order is just adopting the recommended decision as it's written, whereas the second order also requires the additional filing if that date is prior to the date put in the recommended decision, which we've sort of already talked about. But we'll certainly open the floor for questions regarding the two orders or any further discussion on that.
Yeah, and just to clarify, on the alternate EDAM version, it's not an additional filing, it's replacing the deadline in the RD.
That's correct. Yes. So if PNM is operational within EDAM for a year and that date occurs before the recommended decisions deadline, then they will file at that time instead of the recommended decisions deadline.
Yeah, that was my intention, just accelerate the reapproval filing if the world changes. And they certainly can do that on their own. I just picked something that I know would be of interest to me.
Yes. Thank you.
We're seeing in the book and what's in board effect goes through one more formatting review before it gets filed. Sometimes our book edits are up to date with. But yeah, good question. Okay, so then I prefer this concept where we'll tell them to accelerate their next filing if they enter EDAM. I think that side benefit of that, without saying it, is if something else changes the world, they should also accelerate their filing, but think I need to say that. So anyway, I will move for adoption of that order that includes the EDAM benchmark with the edits provided by Commissioner Aguilera.
Second.
Any more lingering confusion before we vote? Nope. Okay, Mr. Cameron.
Commissioner Nyberg,
Yes.
Commissioner O'Connell,
Yes.
Commissioner Aguilera.
I,
The motion to approve the, what we'll call the EDAM order with the edits proposed by Commissioner Aguilera passes unanimously, Mr. Chair.
Great, thank you. All right, next up is 2300299 UT, formal complaint of Rashid Abi Habib against CenturyLink. And that's Ms. Herrera Walter.
Thank you, Mr. Chair. As a reminder, this matter arises out of a consumer complaint against CenturyLink. However, as I spent some time talking about this matter during our last open meeting, I will keep this presentation brief. I want to make sure I'm not interrupting. Okay. So before you today are two orders. The first order was presented at our last open meeting, which dismisses the complaint for lack of jurisdiction, and the alternative order dismisses the complaint for lack of prosecution. I will go ahead and open the floor to Commissioner Nybert to speak on this second order, and then I'm also happy to answer any questions.
Thank you, Mr. Chair. I proposed and certainly see some value in entering the alternative order for a couple reasons. Number one, what do we as commissioners know? We know that a complaint was filed. We know that at some point the parties have not done anything. In November of 2024, you know that you issued an order demanding a response, and no response was given. And so I think an order dismissing for lack of prosecution and for failure to respond does two things. Number one, it sets some precedent that if people aren't pursuing their complaints that they filed with this commission, that we are going to dispose of them. Secondly, it also says that if you don't adhere to our orders, there's some consequence to your failure to respond in this case, or your failure to do what this commission says. So I would argue that we ought to dismiss this case for the things that we actually know at this point in time. And so I would, at the proper time, Mr. Chair, I'll certainly make the motion to dismiss for those two reasons and adopt the alternative order that's before us.
Great, thank you for that. Commissioner Aguilera, did you have anything? I have a few things, but.
yeah, I do. Commissioner Nyberg, thanks for highlighting the idea that this would create the precedent. I think that's why this conversation is important, which is also what I was picking up on. However, I think I see that whole issue differently for a couple of reasons. One reason is because there is no evidence in the record to suggest that this issue is still open. The company here says that they corrected the issue, and that hasn't been disputed. The other reason is because this is a pro se party. And to me, that there is some weight to that. I think that if we were talking about a more sophisticated party with resources like a regulated utility, absolutely, we need their response. But this is a customer. They don't have those same resources, and also it seems like they're happy right now. At least they haven't complained again. I'm concerned about that precedent that we would be saying, hey, pro se party, if you don't respond, we're going to dismiss your complaint. And actually, I'll add a third reason to that is because we did ask them eventually to respond, but that was a year after they submitted their complaint. So why, at that point, they might have lost faith that we're even looking at this. And that doesn't sit well with me. And so it's a year later, and that also is a factor that I'm considering here. I don't think it's fair to say we're not going to do anything with this complaint for an entire year, and then we're going to ask you a question, and if you don't respond, then we're going to dismiss your complaint. I think we need to take some ownership and fault in that fact.
Mr. Chair, we do have evidence in the record, or the record does not reflect that either party has done anything for over a year. And even though it's a pro se party, if this commission, I don't have a problem with treating pro se parties with great deference, but at some point, this commission has got to enforce its orders. And if you ask somebody to respond and give them a time period to respond and don't follow that up with some action, then our order has no impact. And so, the courts around the state do give great deference to pro se parties and give them great leeway in their attentiveness to rules, procedure, and give them wide berth. But an order that requires a response within so many days and there's no response, we ought to follow that up with some action. This order does not prohibit them from refiling their complaint if they wish to pursue it. But it does allow us to clear our docket of a matter that seems to be going nowhere and probably has been resolved. I think the precedential nature of what I'm suggesting is important, not only for utility companies that come before us and those that are really lawyered up. It's also important for people who come before us, request relief, but then don't follow up. And there's got to be some mechanism for us to clear our docket, to clear our caseload. And certainly we asked in the month of November for a response. There's been no response. So I don't know that, if I were a pro se litigant and things have been resolved, I wouldn't respond either. I think it's going away. So I think this is more a formality of clearing our docket. If the parties disagree with us, they can appeal it, or the complainant can refile their complaint and start a new process for the same action, because we're not dismissing with prejudice. So that would be my response to that.
Well, thank you both. It's funny because the concept is a formality of clearing the docket. That's the domain of the consent agenda. So the value of it not being on consent is a concept that Mr. Aguilera has talked about a bit as we've been trying to improve the commission over the last 2 years, and are very much committed to continue to improve it. I like that we're digging into this one because there's only one variable, really. So it's it's an opportunity for us to understand each other and improve going forward. Then when I read the thing, not a lawyer, the only part of the sentence that really matters to me is the matter is dismissed. So then I needed to ask around to try to get some context information on whether these two next phrases, lack of prosecution, lack of jurisdiction, were important. And I think you both talked about why it's important, right? 'Cause and the audience is the community we regulate. So those are both fundamental. Awesome that that came up today. And then my tour of many lawyers, because another thing I try not to do is argue with people who argue for a living. So I didn't want to get myself arguing, for one of these things or the other, just working for understanding, right? Is absolutely lack of prosecution is probably the best reason to dismiss the complaint. But in this context of we're communicating through our orders, it's also valuable to tell them, don't bring this back because there is no jurisdiction, right? So if we just say lack of prosecution, in theory, the complainant could just turn around and file the same complaint again. And we've wasted their time and money. We've wasted the company's time and money. We wasted our time and money. So what I'm exploring here is, again, not a lawyer, should it be lack of prosecution with prejudice because there is no jurisdiction? So then we're telling them not only is it dismissed because you didn't pursue the complaint, but it's also not a complaint we're going to hear.
I think that's a good question, Mr. Chair. I guess it sounds like we would be dismissing it then for two reasons, which is, or multiple reasons, yes. I think one of my concerns would probably be with Commissioner Aguilera's mention of possibly this being precedent for future complaints coming in front of the commission and telling pro se complainants that if they don't do anything after filing their complaint, then they're at risk of dismissal for lack of prosecution. I think in this matter, it makes sense because we did file an order saying respond to us or respond to the commission, and there wasn't a response. But I can see how this precedent could be set for future complainants that are not in that situation, and it could be precedents for the commission that now once a complainant has filed their complaint, they're responsible for moving it forward, whereas my understanding is really it's on the respondent to respond, and then it's on the commission to make a decision. So I can certainly draft something to that effect and bring it back for the commission to vote on. But I do think the first, I guess, realm of analysis would be whether there's jurisdiction or not. And just based on our rule, dismissing must dismiss or shall dismiss is what the language says for jurisdiction, makes sense in this matter. As I guess the primary reason for dismissing. Those are my thoughts, but I'm happy to.
Yeah, no, I mean, that's where I landed that's a good reason, but lack of prosecution is a more direct, clearer instruction. Whether you're pro se or not, if you're gonna complain, you have to follow up. So that's why I landed on. I like the concept of lack of prosecution as a reason to dismiss this complaint. Just then took it to the next step. Well, then how do we communicate better? Because jurisdiction is also a reason, right? So don't leave that out. So that's where I was coming from. And again, not a lawyer. I may just be making things worse, not better.
Yeah, and right, so the rule does talk about lack of jurisdiction, and so in that way it's cleaner because it's more directly tied. That I don't think it precludes us from dismissing it for another reason. So I I do think that lack of prosecution is valid. In fact, I didn't offer an alternative version here, but I actually would have dismissed this as moot because it seems like the issue is resolved. But and not offering that alternative here, just to be clear.
Let's brainstorm up 3 more.
I know. And so I don't think there's anything incorrect about the lack of prosecution. I don't like the precedent. I think the precedent is important. I think under these circumstances, this is not the right case to set that precedent. And there is some precedent, although unclear whether that's for pro se parties.
So I don't believe the case that I found when the phrase lack of prosecution was used was pro se parties. And I agree, Commissioner Aguilar, I think the lack of prosecution question will likely come up in a case before the commission where there isn't a jurisdictional issue. So I do think the commission, if the commission would like to address it, set precedent regarding lack of prosecution, then there will likely be an opportunity at a later time. Because we're not also grappling with this jurisdictional issue here. And so, but yes, I believe the precedents that I did find when we, when there was some dismissal for prosecution, it just wasn't the same situation. It wasn't a pro se complaint.
Right. And then I do think that one of the things you mentioned, Chair, is really good, is that this doesn't answer the question. Well, I think you said that this gives clear direction, lack of prosecution, but I think it actually does the opposite, because as you stated, they will not know that they can't come back. If we dismiss it because we don't have jurisdiction, they know they cannot come back. And so I think the first one is clear. All that being said, I think there is some merit for the lack of prosecution. It's not my favorite, but I would not vote against it. If we did vote for that order, however, I also think it's important to make sure that it is in the context, it is in the format of our template, because it's a much simpler order that doesn't provide the background. And I cannot remember if we already provided this background in our order in November, but I think there's also benefit in sticking to the template. And then I would also suggest highlighting whatever precedent was found, even if it's not exactly on point, where we've dismissed for lack of prosecution.
I think I would argue against both of those. Courts and any adjudicatory body is hesitant to deal with the issue of jurisdiction unless it's absolutely necessary. The issue of jurisdiction has never been brought up until 2 weeks ago. So we can dismiss this and resolve this case, and the likelihood of appeal is approaching 0. And so we can resolve this without even addressing the jurisdiction issue. And I think we ought to follow generally what courts do, and that is dismiss matters on the simplest terms possible, which may get to the formatting issue as well. I think dismiss this in one sentence makes a lot more sense than going through the whole history, particularly in this case. If you want to insert jurisdiction, we're dismissing for jurisdictional issues, then you have to ask the question, why now? I told you what I know. I've not looked at the statute regarding jurisdiction. Council obviously has. In fact, I purposely not looked at the statute because I frankly don't want to know right now. But it seems to me that anytime a complaint gets filed before us, jurisdiction is the first issue to be addressed. That was 1.5 years ago. This commission's entered several orders. In fact, 2 months ago. It had no, if you're arguing jurisdiction, you had no jurisdiction to enter the order. So let's dismiss it for as simplest terms as we can and not bring in questions that in my mind, we don't have to answer at this point in time. And like I said, I don't view this as a matter that's going to get appealed. I frankly don't view it as a matter that's going to be refiled either. I think the likelihood of either of those events to occur approaches zero. And so I would dismiss it on as simplest terms as you want. We can dismiss it just for failure to comply with the November order and take out the other language. But I would do it as simply as possible, and I would do it as quickly as possible, because you have other issues that come to light there as well. So that would be my response. Get rid of this case as easily and as quickly as we possibly can.
Well, thank you for that. And then frankly, what you just said reminded me of another option, which was what has happened before in the commission, is you do nothing and then wait 20 years, like, why is this case still in the docket? So you'll see some of those. We're still clearing those out. So anyway, just all I wanted to say was answer to your why now question is pro se. The rules are different for pro se. The practice has been different for pro se. That's more of an art versus science. I think, Commissioner Aguilera pointing out this thing's moot. I agree with that too. So I think we've gone beyond the being extra generous to pro se on this one. So that's why you convinced me that let's just dismiss for lack of prosecution with the simple order is a good choice for today. And then again, don't want to belabor the point, but I really value the conversation, especially on something where we could dig in without worrying about what we were doing to the world and the customers. So that's how we get better. So thank you to all who participated in that. And then shout out to Mac Lee. He also was part of my, how do I understand this stuff? So.
Mr. Chair, you said something that I'm concerned with. We have different rules for pro se. That would raise an issue of due process. That would raise an issue of equal protection. I think we have to have the same rules. Now, what courts do is give wider berth, give more discretion to pro se litigants, but you have to have the same set of rules. You have to enforce the same set of rules on any party that comes before us. And frankly, our expectations ought to be the same. Now, that doesn't mean we don't try to work with, and I'm not suggesting that anytime we see an issue that comes before us and nobody's doing anything, that we immediately dismiss it. I think we ought to send the letter that says, hey, are you going to do anything with this or not? If they don't respond, then enter the order that demands a response, and then do exactly what you did in November. And then do again what I'm suggesting in January to get rid of the docket. But I would hope that that we don't have two different sets of rules, because that would really impact many of the arguments that come before us.
And just to clarify, Commissioner, I think in terms of like courts, we construe pro se complaints liberally. And I think that's just what the chair was getting at. I'm not aware that there's actually separate rules.
No, and our rule tells us to do that too. So that's where I was coming from. You will see the phrase in our rule that pro se gets more.
Right, I think all parties that come before us that are represented by lawyers know that pro se litigants get a much wider berth than others, sometimes to their chagrin.
And we've had instances where somebody showed up as a pro se complainant and we told them, you don't qualify for that, go get a lawyer. So anyway, that's where I was coming from. If you read the rule, there is a pro se is called out specifically and differently. I don't think it is as alarming as I led you to believe,
Yeah.
but anyway, I'm ready to move for approval on the order dismissed for lack of prosecution.
Well, then, Mr. Chair, I'll move for the adoption in case number 23-00299 UT for the alternative order, final order dismissing the complaint and closing the docket in this case for the reasons stated.
Yeah, I'll second that and then we can discuss before we vote. Discussion, have we belabored this?
Oh, I will have some discussion, but I'll do it after the vote.
Oh.
Yeah. Explain.
Commissioner Aguilar,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Nyberg.
Yes.
The motion to pass order number 2, which is the one that dismisses for lack of prosecution, passes unanimously, Mr. Chair.
Great, thank you. And again, thank you for helping us work through this. I learned a lot. I think there's value there. Well, we'll see in the future if there's value there. The proof will be in the pudding.
Yeah.
But,
And
anyway, take it away, Commissioner.
yeah, so to explain why I voted aye, I think I agree with the outcome to dismiss the complaint. So I think that's correct. And that's ultimately why I voted aye. I agree that there is value in this discussion. I also agree that there's no chance of appeal here. I think it's very likely that this issue is settled. What is important is the precedent that we're creating. I do not agree with the precedent we're creating given the circumstances. The ball was in our court for over a year to do something. We didn't do anything. Had we issued this order about lack of prosecution November of the year before, I think it would have made more sense. But that's something that I'm considering. That being said, I do agree that people need to respond to our orders in reading into our rules, that we have to, not reading into, but reading our rules that we consider complaints by pro se parties more liberally. I would have preferred to dismiss the complaint on other grounds, such as lack of jurisdiction. Thank you.
Again, thank you all. Thank you. We're moving into the next piece of our agenda and my water glass is empty. So I will propose a 10-minute recess. Or 10 minutes, 10, okay. Well, there are donuts out there. So we will reconvene at 11:45. All right, welcome back. Moving on with the agenda, the next item is 22-0089 UT. It's a rulemaking to implement grid modernization statute that has been working for obviously for a while here, and we're hopefully close to, if not at the moment, where we can issue the NOPR to finalize that order. So start with presentation from Mr. Lundin, just to remind everybody where we're at in the process and what we have in front of us.
Good morning, commissioners. So today we're on the discussion potential action agenda. I'm not directly asking that you vote on an order today. However, that is a possibility. What I have for you is not just a recommendation from OGC, but from the drafting team of advisory staff who have prepared a proposed rule to commence a formal rulemaking process on grid modernization. With that, it is also a proposed order. And first, I'd just like to do a quick little history because I think it's important to highlight the foundation that the commission has built to advance to this stage of the rulemaking. Legislation was passed in 2020, which created the grid modernization statute, spanning 3 different makeups of the commission. Going back to 2021, the commission began its inquiry into a grid modernization rule. And at that time, it wasn't sure whether or not it wanted a rule, but it was kind of testing the waters. And over the last, 3 or 4 years, the commission has issued several bench requests, received hundreds of responses on those. It's held 5 different workshops, not just with regulated entities and stakeholders, but with outside expert groups such as Lawrence Berkeley National Labs, GridWorks, the Minnesota Public Utilities Commission, among others. And then this has kind of the informal phase has culminated with the drafting team drafting a draft rule, which was shared with the public back in November. Again, we've received many responses on the draft rule, and that's sort of kind of the, I don't want to say the cherry on top because it's a very important piece, but it's the culmination of this long informal process that's helped the drafting team to come up with the proposed rule. And what the proposed rule is, it's the drafting team's recommendation for the commission to adopt as law. Now, with the NOPR order, the commission would be saying, or communicating to the public that this is the rule that we want to promulgate, and this is your opportunity to comment on it and change our minds or not. So that's kind of the history here and what I'm asking from you. The proposed rule, kind of, you can boil it down to one sort of main topic, and that's the grid plan. So the grid plan would be a public utilities 10-year plan. It would be filed every 3 years, and it would be focused on the grid planning kind of aspects from the grid modernization statute, basically to improve the electric distribution system, improve the infrastructure and assets and technologies that we use in our grid. The grid plan would be filed every 3 years, as I mentioned, and it would be composed of a 3-year action plan and then the 10-year horizon as well. The rule additionally provides provisions for grid plan cost recovery and also for grid modernization program cost recovery, which are 2 separate pieces of kind of like the same puzzle of cost recovery. But the statute that we're working from, it defines what grid modernization is. It tells the commission what it has to do as far as evaluating grid modernization programs, and it sets parameters for cost recovery, but it doesn't provide this broader regulatory kind of objective, and it doesn't give the commission granular detail on what to do when it's approving programs other than to consider such the 7 factors. Therefore, the rule is meant to sort of take the statute and put it into commission practice. And typically what the commission has done with a lot of other aspects of its regulation is highlight the utilities planning and put that into a triennial kind of cadence where they come back to the commission every 3 years, engage with stakeholders and have a public process along with it to continue its planning over an indefinite period, but every 3 years at minimum. So that's my presentation. I know, I provided you the proposed rule, the order. I know that each of the commissioners here has some edits that they've proposed in recent days to the rule. So if maybe that's the best basis to begin our discussion, but the floor is now yours to speak about grid modernization. Thank you.
Thank you, Mr. Lundin, and thanks for the background on that. This is, in my mind, an important rule. If you look at costs of services and rate cases, the distribution system is significant chunk of what goes into rates for utilities. And then my background is planning, so I really firmly believe that maybe the Eisenhower quote that plans might not be the best, but planning is indispensable. So sitting there and looking at what's the most important thing to spend your money on, and then identifying potential solutions, getting a buy-in on that, and then proceeding is a way to achieve this lowest cost, least cost objective. The other reason this stuff is true is now more than ever, customers have ability to make different choices about how they want to use electricity. The rule talks about rooftop solar. That certainly has happened. It is happening, will happen, where utilities have proposed several state laws about, or several plans for vehicle electrification. So that's a situation where you've got potentially a new load on the distribution system. It's a diverse load, and if you can encourage it to happen at certain periods of time, it can actually save you money because you'll be using unused system when it's not being used. If you can send price signals to customer, they'll know, hey, if I charge my EV now, I can get power at a very low price. So those are the kind of things that are available now that didn't exist. And then finally, the utilities all need capacity. One of the pieces of the big picture of capacity includes demand response. So what utilities have been doing is just direct load control, usually tied to refrigerated air. Direct load control is just a two-way, communication system where a utility can say, hey, I'm going to cycle your refrigerated air differently. So it's going to lower peak demand, reduces the amount of generation capacity I need. That's been successful to an extent, but we've approved AMI for every utility. So that creates opportunity for much better demand response programs. They can be two-way. If you have a electric hot water heater, for example, you can take those offline when supplies are tight, like cold winter morning, for example, instead of hot summer afternoon. Or if it's middle of the night and wind's blowing, you can use that period of time to create the hot water that they're going to need when they wake up in the morning. So you can, those are the kind of things that are available now that is not the answer, but a piece of the puzzle for how we can move forward. So I really applaud the work of the drafting team and people who have contributed to putting the rule together to get it to this point. Having said that, there's still some things I would like to improve about the rule before issuing the NOPR. So I'm happy to talk about those when appropriate. Not seeing any volunteers, so do you want to go ahead?
Thank you, Mr. Chair. The one issue that in reading this, I came to my mind was we have a 3-year cycle on these plans, but we have a 5-year and 10-year other benchmarks or other timeframes. And I'm wondering, should the plan be filed every 5 years? Because the planning process is fairly expensive and requires a lot of work. And is 5 years a better number than 3 years? Because it fits more in line with the other 5-year and 10-year cycles. So should they only go through this fairly elaborate and I would suggest expensive process every 3 years, or should it be 5 years, which helps coincide with some of the other benchmarks that are in the draft that I see before me?
Are you asking for a response?
Yes.
So first, Commissioner Nybert, perhaps there was a slight misunderstanding, but there's not a 5-year benchmark in the rule. So the grid plan would be filed every 3 years. It would be composed of a 3-year action plan and the 10-year planning horizon. And then there's other little pieces that, like the hosting capacity analysis, would be updated annually. But yet the 5-year I think requirement might have been an artifact of an old draft.
I know I saw 5 years in here somewhere.
And then just one comment on the 3-year filing cadence. I think the idea there was to tie it to the outcomes of the IRP and to have these two documents kind of operate in tandem with each other. So if it's on a 3-year filing cadence, then it matches with the IRPs of the utilities.
So if the IRPs are filed every 3 years, that requires a public hearing process as well?
Yes, sir. The IRP process has a public advisory process that I believe starts 6 months before the filing of the IRP. And it involves a commission facilitation.
Would there be any benefit to having them in conjunction with one another, or the issues so widely so far apart that that wouldn't lend itself to much economy of scale?
So I'll give an answer, and I know Art O'Donnell's on the line. If he wants to chip in afterwards, that'd be great. But from my understanding is that the goals of the IRP and the goals of the grid plan are sort of separate. Where the IRP is looking at generation assets, the grid plan is looking at these grid modernization technologies. So I mean, perhaps there could be some efficiency to gain there by combining processes, but to do that, I think would require amendment of potentially the IRP rule as well, and potentially a larger overhaul to kind of what this rulemaking is doing currently.
Well, my concern is because these are fairly large tasks, and ultimately the consumers are paying for this process, is trying to make these processes maybe less expensive and maybe more economic to do all the additional planning that we're now requiring of them. I agree with the chair that we have to go through these planning processes, but the planning processes, we should not require planning processes that are unduly burdensome and also don't accomplish a real purpose. And so the timeframes, the frequency, all that should be looked at. It should make sense. And I just saw different numbers as we discussed the other day in the document. But if 3 years makes sense, 3 years makes sense. If we need that data every 3 years or plan every 3 years, if it makes sense, I'm not objecting to it. I just want a number or a frequency that makes sense, and is also doesn't cost more than the process should cost, because companies get to pass all this stuff along. In fact, there's provisions in here to pass these costs along to the consumers. So that will be my focus, is just to try to make sure there's some sense as to the frequency and the expense of the process that we're requiring of them. Thank you.
Yes, sir. And those are all very appropriate thoughts and concerns. So that's stuff that the drafting team does, take into account and thinks about. But for today, this is the proposal that the drafting team has for your consideration. If it doesn't get voted on today, I mean, there's time to readdress some of these issues.
Yeah, thank you. And frankly, the issue you raised, Commissioner Nybert, is related to something I wanted to see in the rule and haven't succeeded in hearing back from drafting team for why it's not in there really yet. And one is there's quite a bit in here about CBA, cost benefit analysis, and I agree with that. I think that's all good. We also had received presentations from experts helping guide the drafting of this rule, and one of them highlighted, there's different ways to pursue that. There's the cost benefit analysis, and there's also a concept called least cost best fit. And so my understanding of that what we heard from, again, the expert we brought in to help us with this, is when you're looking at a program of options, a big plan with lots of elements to it, cost benefit analysis is necessary. And so that's the kind of thing we asked all the utilities to do, or they provided it on their own to determine their first grid mod plan that included AMI was reasonable, was show us cost benefit analysis. Once that program's been approved and the concepts and elements have been approved, then you get into this cycle of continuously building out the program or the plan that's been approved. A least cost best fit is a very good tool that allows utilities to show we're working through this plan, we're responding to changes, and we're still pursuing it in a least cost way. So if you stretch out a planning period to 5 years, and then you can have compliance filings in those 5 years with, instead of requiring a CBA for absolutely everything, you can say, if this is not a new concept, show me that you've pursued it with a least cost best fit. So I've been trying to get that included in this draft rule, just on a footing that's similar to what's in here already for cost benefit analysis. And then maybe a little bit of guidance about when it's appropriate and when it isn't. So that's one of the things I would like the drafting team to either explain to me why it isn't in there, or let's take the 2 weeks and whatever and get it in there.
Thank you. Appreciate those comments. With respect to the time frame, I think what I would note is, yes, there is a lot of work that needs to go into the process, and there also we need to be cognizant of the cost of all of that. That being said, as the chair was just mentioning, the cost is a factor in the plan. And so in theory, this should benefit customers. And so, if we do it more frequently, in theory, they could get more benefit. But more than that, we've got some catching up to do with the grid. And I think that there are situations where it would make sense to have it every 5 years. I think that given the, what I hear kind of from the legislatures and bills that are proposed, I think improving the grid is a priority. But that's certainly something we can talk about what the frequency should be. The two things that I wanted to explain that I was thinking about is, first is grid enhancing technologies. I think there's room in here for us to make this a larger part of the plan. And I think it is somewhat there when we talk about non-wires alternatives. I think it's very similar, if not the same thing. But what I wanted to see is that to be highlighted more, because these are situations where I think we can use the grid more intelligently without spending as much money. So what are non-physical, or maybe sometimes it is physical because there's like some computer software, and you need the computers, but what are other ideas that we can implement where we can maximize the use of the grid? And so to me, that is one thing that I would hope we could focus on more. The other part of it is the stakeholder process. I think that the deadlines and that are provided right now are kind of tight. It doesn't give stakeholders very much time to look at the draft plan. The other thing that I think is important is to make sure that the utilities are providing the stakeholders with the assumptions and the inputs to their plan. They might be assuming a certain amount of growth. Stakeholders won't be in a position to provide valuable feedback to that if they don't know what the assumptions are that the utility is working with. And so those are a couple of things that I wanted to mention.
Yeah, thank you for those. And then frankly, you segued nicely to the other big thing that I was looking for. And it's really, there's a couple concepts that if you squint really hard, you can see them in the rule, and gets is a good example. The other is, for me, the way the definition of what a DER is doesn't strike the right balance. So it's, distributed energy resource, but first draft I saw, it just said this is a rooftop solar thing. It didn't, it said more than that, but the way it leaned into that as part of the definition, it was very narrow for what a DER is. So then anyway, that was level of responsiveness I got from drafting team, is they just deleted the word solar, which didn't get it to where it needed to be, really. Again, more balance, that a DER can be something that injects power on the grid, but it can also be something that is useful management tool by taking power off the grid, because especially in this variable energy world that we're already in, there are times where we've got surplus energy, and let's make use of it in valuable ways. So again, if you squint really hard, you can see that a DER is something that allows power to flow both ways, but the balance of what's drafted here doesn't communicate that. And then, your point about gets, that's not just what should utilities be planning for, they should be planning for enabling customers to use electricity as they're going to use it. The other is then how are they going to address it? And it's a plan that really, least cost planning probably means optimizing the system you have as you're preparing for, or to bridge you to a big investment that you need, because we need a bigger grid, right? So things like gets and fit into that. The tone of this, or the balance of what it communicates, doesn't clearly tell utilities that's important, included in your plan. It just says, oh, by the way, maybe you could think about this one thing. So it's more just as a reader, when I read this thing, what does it tell me to do? What I want to see them do is kind of in the exceptions. It's not the instructions of what the rule says. So that's why I didn't have big edits on that, but the big edit that I was looking for was least cost best fit and rewrite definition of DER. But I would love to see a better balance in what the plans need to include on the back end.
Mr. Chair, I will expose my inexperience and possibly my ignorance on some of this, but can someone explain how this proposed rule will interact with at least in my hometown, the fact that we're subject to the Southwest Power Pool, how grid modernization interacts with, in that case, the regional transmission authority, and how the two may mesh, if at all. And secondly, will this effort be something that would help alleviate in the future the current situation that exists in southern Lee and Eddy counties, in that there is insufficient energy going into that portion of the state to accommodate the demand? Does this help at all? And again, I'm exposing my ignorance. I don't know how the two overlay with one another, but I would be interested in learning that, and we can do it offline if you wish, but that's something that'd be important for Southeast New Mexico, as I see it.
Yeah, I'd say the answer is if it's done well, it can help. Is it the solution by itself? No. This is planning on distribution system, so the Southwest Power Pool is kind of the bulk power system. So things like if SPS can use a good distribution plan to also develop a substantial demand response resource, then they can sell that resource into the Southwest Power Pool to the benefit of customers in their service territory. And it also, again, on the margin, will reduce the problem you're describing. It won't solve it. So anyway, it's not the thing that by itself solves the world. It's the thing that if we're not doing it, then stuff can get really expensive really fast, because all you're doing is the big, more expensive, hard to build things. And then the reason I like it, it's also about putting decisions in customers' hands. Whether they choose to do that or not, it's up to them, but give them the opportunity.
I don't have any further color to add to that conversation.
Drafting committee member Arthur O'Donnell. Love to hear what you have to say, Mr. O'Donnell.
Mr. Chair, Commissioners, thank you very much. You can hear me okay? Thank you. I'd like to address a couple of things. I think we may be suffering from version lag. I know that we had a meeting earlier this week and we specifically addressed, and it was my assumption that the two things that you were talking about, Chairman O'Connell, were incorporated into the rule, the proposed rule. I will point out that in the definition of DER that is before me, in section it is a D under 2, which is the definition of DER. It says DER may be capable of exporting active power to an electric power system. The DER includes the customer's interconnection facilities and shall not include area power system, blah, blah, blah. So we did make the effort to incorporate that. We also, I thought we had agreed that we would add GETS reference in there. I'll just mention that GETS is slightly different than the other construct in that non-wires alternatives, in my view, is a market kind of concept, which is that you're out looking for generation or demand response or non-wires alternatives. Those non-wires alternatives may depend entirely on grid enhancing technologies for improved sensing of the system, automation, those kinds of things, which are kind of part and parcel of how the legislature defined grid modernization technologies. So I think that we aren't planning on a vote on this this week, but we will make sure that you get the final version to be able to speak about. And I did want to address something of Commissioner Nybert's question about the cycle. There were two main reasons. We already identified the fact that we wanted to align it with the IRP, and the IRP is about generation, of course, and this is about how you deliver that generation, especially new generation that may be coming from different places than you have in the past through your system. So while they are similar, when we initially going back 3 years now, taking initial comments on our ideas about this, there was a very strong pushback from utilities and from the utility division staff not to incorporate distribution planning into the IRP process, but to have separate processes. I personally believe that in the long run, they should be combined, but we're not there yet because we haven't even been through an entire 3 utility cycle of doing the IRP. And we need to work out some bugs on that. As for and also the alignment is that the distribution plans would come in between the IRP filings in order to, one, take advantage of the loads and assumptions that were alluded to, updated to the extent possible and informed by what the utilities actually do as a result of their IRP filings. For instance, going out to market, signing new contracts for new resources, and then you figure out where the distribution facilities need to be in order to deliver that effectively. So that was really our thought. In terms of the cost, the actual process for this, I expect would be not a doubling of the process that was approved for the IRP for 2 reasons. One is that we would be able to take advantage of the work that was done in IRP, saves you a lot of time. You don't have to go through new models unless something significant is changed. You just update them, and certainly the stakeholders want to know what those updates would be. The commission wants to know what those updates would be. So that's what we were envisioning there. But also, this is more than the IRP, which had a lot of public interest, and at the time we started the rulemaking for that, had a lot of controversy in that the commission didn't have very much visibility into the utilities processes. This, we've already addressed visibility of the generation, offering visibility into this process and participation, but not through a facilitated process that does incur costs, but a utility run process. So that makes it a little bit different than the IRP that we proposed, mostly because we felt that the issues would be more self-evident than trying to decide among various generation types of resources. You're really just working with a common set of technologies for distribution. And the question here is, where do we put them to get the most bang for the buck? Right. So it's a different level of analysis. Things can always be improved. My personal feeling is that we really need to run through this to see what can be improved, but and take comments on it, and that's why we're asking for the NOPR. If there's anything else that I can address that I may have missed, please remind me.
Yeah, thank you. For me, the takeaway was let's avoid worrying about version control by just benefiting from today's conversation, put it back on the agenda in 2 weeks and vote on it. Make sure drafting team knows what version we're voting on and vice versa. And then I also agree with what you said, Arthur. We have done enough work here now that I'm ready for a NOPR. I just think it's worth it to settle any version control issues we might have. Maybe we don't. I'm just reading it badly, but the big thing I'm not seeing in here is least cost best fit. But and yeah, I hear you on the revision to the DER, but like I say, it's also just take it from a reader point of view. How many words are being spilled on which topics? And that tells you, gee, this is important because there's a lot about this topic. But then if there's just one little mention in passing, it doesn't, for a reader, communicate that that's important. And so there's a few things that are kind of buried in there that I think are more important than the treatments I've seen in previous versions of this rule. So if drafting team could take that note and think about it, I'd appreciate that too.
Mr.
Thank you. And I
Chair,
do believe that we had discussions, and I thought that the least cost best fit provision was bolstered in the last version, but we will make sure of that. Thank you very much.
Mr. Chair, on an unrelated subject, this is the third rulemaking that we've considered this meeting, and my question is, are we prepared and do we have the resources to engage in 3 rulemaking proceedings at one time? Or should we space them out?
Oh, it's worse than that. No, I mean, we do have the resources for what we've stacked up, because you know, the SRUSF rulemakings are pretty lightweight. There aren't very many people. The resources required for this have already been invested, really. I mean, not trying to minimize your time, Mr. Lundin. He has a small child and has to sleep, but
No, he doesn't sleep.
so anyway, getting another round of comments, addressing the comments with the foundation that's already been laid isn't a huge lift for us. So anyway, that's the things that you saw today. We do have lingering in the background some other rules that haven't moved yet. And like one that's near and dear to my heart is Rule 1.2.2. That's our rules of operation, and it includes things like electronic filing and you know, just how you file a case, those kind of things. So that one is a big one. That one is close. We've invested a lot of time and resources in that one, but I would expect there'll be more comments on that one because it implicates absolutely anybody who files anything with our commission. And we've got a lot of internal stakeholders that have things to say about that. So that one's very important. We've been working on it for 2 years. We haven't moved it to this point yet. So that was the conversation Mr. Lundin and I were having just before the break, is how do we highlight what needs to be done and make sure things are being stacked in the correct order. And then if you'll remember from, I think it was the last meeting, there's a energy efficiency rulemaking that's about, you know, updating the rule because of, well, that was the workshop we had, first week you were here. That's another one that needs to move because of, I'd say, statutory reasons, just comply with the law. So maybe that one is higher priority than 1.2.2, but I think substance of it, 1.2.2 is as important as anything we do. So how do we make those choices? That was the conversation Mr. Lundin and I were having coming out of the break. So maybe that's a good takeaway for the next meeting, is let's have a priority setting conversation. Pick up everything that's been worked on, isn't done yet. And then try to stack the order. But yeah, the fact that we're able to work on rules, frankly, is a bit of a luxury because when we first arrived, there were a lot of big cases. And so we had a lot of rule makings that just kept getting pushed off because of the press of other business. So the fact that they're bubbling forward is good. And all of them are valuable. What order do we pursue them in is a good commissioner level question. And any advice you have, Mr. doesn't get to sleep.
I was just gonna say, there's one more you left out, the rural co-ops renewable energy rule. That one is ready for a final order though, so we're past the NOPR stage.
For that. So that's something that we can work on between Meckley and Robert and OTC, just get a list of all the rulemakings, where they're at in the process, and then we can have a conversation on that list and maybe make some choices. Okay, so I'll tell you what I'd like to do is let's collect what we did here somewhere in the next week. This is the version we're voting on in board effect, and then vote in at our next open meeting. Is that any objections to that approach? And then again, always tremendous gratitude to you, Mr. Lundin. You carry a lot of these rule makings, and they're important, and you get pulled in a lot of directions. Let's just put it that way. So thank you.
Yeah, just one last note on the version control topic. So we did review, the drafting team reviewed edits submitted by all 3 commissioners and agreed on, you know, those like such as gets and least cost best fit that we can incorporate into the rule. That wasn't finalized until late yesterday, and I just didn't want to bombard all the commissioners with significant edits right before the open meeting, so that's why that wasn't shared, but it is, the drafting team is working from a consensus final rule, which will be shared with you soon.
Well, if that's the case, then just maybe take a beat and think about how is this ruling communicating what's important? I mean, we've got a lot in here about AMI. It's all good, but most utilities have already filed for AMI, so I think it's worth keeping in there, but it makes it look like this is an AMI rule, which I don't expect that to matter much going forward. Thank you, Mr. Lundin. And looking forward to two rulemaking conversations in 2 weeks. Yeah. Where are we at? Okay, next up on the agenda is our legislative update. We got Jerry Monez from the Chief of Staff's office. Another person who's not expected to sleep.
Good morning. Okay, so last week we had our internal training and staff has hit the ground running. So far as of end of day yesterday, 210 bills have been filed. And we've analyzed 6, but since you started your meeting, I've had a handful of other requests. Right now, the committees are just working on their organizational meetings and getting started, so nothing has been scheduled. On our bill, we have our Pipeline Safety Act bill that Senator Sewell is sponsoring, and that is SB 9. That is the only one of our bills that's received a number. I told you in the last meeting that our PRC Public Regulation Commission Act was pre-filed also by Senator Sewell. However, it has not been read into legislation yet. There's still a lot of bills that were pre-filed that are just still getting read into legislation. And as they are, then they'll receive an actual number. So hopefully the next time we talk, I'll have numbers. The committees for the Pipeline Safety Act bill are the Senate Tax, Business and Transportation Committee, and then Senate Judiciary. So it only has 2 assignments, which is great. So we'll be following that. Other than that, I'm just watching the bills, and I'll continue to meet with each one of you, and then we'll have a regular update at our meetings on open meeting day.
Thank you. And then I think we've got a couple presentations coming up. Maybe is that don't want to steal Chief of Staff's communication thunder here.
Are we stealing your thunders? Okay, so Monday, we're participating on a panel for electrification and economic development, and that's at 1:30 at the Senate Finance Committee room. And then right after that, we have our budget presentation. And then Friday, that same week, next week, Friday, we have our House Appropriations and Finance Committee budget hearing.
Great, thank you.
Sorry, Commissioner, I have it, just not in my notes. It's also at 1:30.
So maybe you can help us, Commissioner Nyberg, at 1:30 legislature time. What is that really?
The clock rolls and rolls. I will say that our Monday, after our panel, immediately following our panel, we're supposed to present at our budget hearing. So I would say 2:30, but we don't know.
It's great that things are moving, and I'm glad we're getting an opportunity to participate in that process. Any questions for Ms. Myers?
On the bill that has a number, things tend to get put under the table in Senate Judiciary and never rise to the top. Have you had any discussions with Senator Cervantes or Philip Laragote?
I have not had, Commissioner, I have not had conversations with Cervantes or Philip at this point. And I don't know that Senator Sewell's, I would have to have that discussion with Senator Sewell's, I think, first, just to make sure.
I just know that if he doesn't see the importance of a bill, it never rises to the top, and here in about 3 weeks, you're not going to be able to talk to Senator Cervantes. If you're going to talk to him, it's going to be pretty quick. Just warning you.
No, I don't discount what you're saying. I understand the process. However, right now, I mean, we just want to make sure it gets scheduled in this tax
It's
business.
first committee.
Yeah. And then we can work on that after the fact. But no, I totally understand what you're saying about the bottleneck for judiciary. But I think this will be our first hurdle, is to get it scheduled in tax and business.
Use me as you need me.
I will.
Yeah, the best use of me is stay away, so. But no, I agree. If I can be helpful, let me know. Any other questions? Nope. Then thank you, and looking forward to, you're gonna be a regular feature of the agenda through the session, so.
Speaking of time constraints.
Yeah, next up is Mr. Montoya with our fourth quarter and end of year progress report. Thank you for being here, Mr. Montoya, and floor is yours.
Yes, sir. Mr. Chairman, Commissioners, thank you. First appearance this year, so happy new year. I think we shared that earlier through emails, but in person I have not. And congratulations and welcome to the PRC, Commissioner Nybert. I have Patrick presenting a couple of slides on my behalf because my computer's kind of glitching out this morning. So just want to give you a quick update on staffing and where we finished and actually where we're going to be in the next couple of weeks. And it's a good information for Commissioner Nybert. I think it's kind of a refresher for the other two commissioners, but at the top there, it's just a capture of why the Pipeline Safety Bureau exists, who we are, what we do. It doesn't go into detail about how we do it, but obviously it's to educate, ensure, and if necessary, I guess I should add, enforce safe pipeline safety, pipeline systems and safe excavation. And so we've been busy filling all those blocks in 2024. We lost an individual, a lead inspector, to retirement December 31st. So we are quickly going to be backfilling that position with hopefully another very well qualified person. So hopefully over the next couple of weeks, and I know Chief of Staff is happy to hear that we're going to fill 3 of the 4 blocks that are currently vacant. And so that really helps with our vacancy rate and concerns there, if any. But we're happy with the staff that have joined us. They have been investing a lot of time and energy in learning the do's and don'ts of pipeline safety and have been preparing for the extensive training that they'll be going through out in Oklahoma City. So we're excited. Next slide, please. Or I could pause and answer any questions on vacancy if you, okay. This is kind of a capture all, if you will. It's a very familiar slide that you've seen 3 times. This is now the 4th. And I kind of have it broken down into the 4th and then a total. And I put some additional information on this slide just to speak to. And this is based on a calendar year. As you know, the state functions and operates on a fiscal year. But the reason we do that, Commissioner Nybert, for your information, is the grants that we receive from the DOT Pipeline and Hazardous Materials Safety Administration are on a calendar year basis. And so I like to always report to be consistent on a calendar year basis. So in the 4th quarter, we finished with 18 inspections, even with all the people that were gone on the use it or lose it hours and whatnot. So we totaled 136 inspections in 2024. that actually resulted in about 615 total inspection days combined. And 171 PVs. Well, what is PVs? Those are probable violations. So those are issues that we have discovered with operators and have summarized a notice of probable violation letter to their attention for corrective actions. May or may not have included additional enforcement actions. We always try to work with the industry in correcting them, especially if it's a procedure that just needed to have a facelift to be upgraded to the current rules and regulations. And so a lot of work. I mean, that really is a lot of work. As you know, we've been with the extended staff only half the year. So a lot of the legwork the first 6 months was with half of what you saw on that org chart. So I'm pretty proud of the staff and what they've been able to accomplish. On that note, I would like to also recognize that we were required to do about 535 natural gas inspections. We did 627. So we did exceed our number by about 117%. Of those 535 days, we conducted about 107 of new construction. And because we've been finding recently over the last 5 years, 8 years, that there have been a lot of anomalies that are issues associated with new construction. And that's where we hope to find the issues and prevent them from stemming, after the fact or long term. And we also conducted 80 hazardous liquid inspections. All of that is consolidated into that 136 number. Please feel free to interrupt me and pause if you have any questions as we go along, and I'll be happy to answer any questions when I end as well. On the incidents and accidents, thankfully, we didn't have any reportable incidents and accidents in the fourth quarter. It's always a blessing during the holiday season that you don't have to get suited and booted and go out to the field and get to spend some quality time with family and friends. So we ended up with a total of 7. Of those 7, and I know former Commissioner Ellison asked a question, so I broke it down. 5 were gas and 2 are liquid. Majority of them are just reporting only regulated assets. So under the federal act that we adopt, they are only required to report it. And these are those instances where we believe the regulators, federal and state partners, are going to be evaluating the stats over a certain period of time to say, okay, they're just reporting it. We now have statistical information. What are we going to do with it? And so this is just like the second year that we've had a reporting only criteria. So it's still a little bit of ways to determine what that's going to transpire out to be. But of the gas, of the 5 gas, there was 1 that was federally reported only under the gathering system. So the new gathering rules that we've been talking to the commission about for the last year and a half now. There's only 1, thankfully. So that was pretty remarkable. I will summarize that we have had to issue some civil penalties as a result of inspections. And this year there was 1 down in Deming and the 1 Zia Hobbs. And that tallied to be about 29,500. I bring that up because of the previous presentation by Jerry talked about the Pipeline Safety Act and the violations. So you can kind of see what we did in 2024. Moving on to the next one there, excavation damages reported. You can see here that is a busy number. 595 excavation damages in only the fourth quarter. That tallied to be about 2,503 total, and we've issued through to date anyway. There's some probably forthcoming because we have a 30-day window to close them. 227 notice of probable violations. So in the acronyms that I'm using, probable violations in one letter, there could be 5. As far as the excavation damage reports, there's typically 1 probable violation per notice of probable violation letter. So that's kind of why I summarized it in parentheses for you guys there. And that actually, to break that number down even further, there's 97 civil penalties issued for non-compliant and uncooperative alleged violators, tallying about $310,000, 38 warning letters, and 92 mandatory training letters, where we've decided training is necessary to prevent recurrence. Ultimately, that's our goal, prevent recurrence. Get rid of the repeat offenders, or at least discipline them a little bit more. Maybe not actually get rid of them, but try to work with and teach them the rules and regulations here in New Mexico. What we've been experiencing in the excavation damage prevention program is a lot of out-of-state contractors working on behalf of all the fiber rollout projects that have been conducted throughout the state. And some of them aren't licensed, some of them aren't trained, and they bring over the Arizona, Colorado, Texas rules and regulations and mindset, which doesn't work here in New Mexico. We have pretty stringent rules and regulations. So we've been trying to really focus on trying to teach them the ways to comply even before they put a backhoe in the ground, even before they request a permit from any local jurisdictional agent. So we've been successful in some cases we haven't, just for lack of cooperation or no knowledge at all of who's actually out there digging. So we're definitely going to keep that on our radar moving into 2025 as well. Monthly, we process what's called positive response notice of probable violation letters. And what this is, Commission, is basically after the advance notice period, every underground utility company that was notified of a proposed excavation has to respond, has to give an update status on where they are with their locates, the paint on the ground. If they don't have any, they can clear it. So it has to result in a marked or cleared within 2 full business days. If it's not, then the excavator is responsible to call 811 back and request a warning ticket. Then they're obligated to go and do what they're supposed to in 2 hours. And after that, we issue failure to provide a positive response, which means contractors doing their job, their due diligence, they made a reasonable attempt to protect your infrastructure before excavation. You failed to comply or at least send somebody to cooperate, coordinate, or even reschedule the excavation activity. It's a big number, 582 failure to provide a positive response notice, resulting in about $840,000 in civil penalties. Because there's really no corrective action if we have to go back in time 45 days ago, 60 days ago. And so we've been monitoring activity, and if we're always pushing for a downward trend, then we have the ability to have compliance or settlement conferences and take corrective action companies have been implementing. But unfortunately, the majority of the telecommunications industry either doesn't care or has the money, deep pockets to pay the bill. And so
is that an ongoing thing? Because I mean, I remember when that started and we were told, hey, watch out, there's going to be a lot of investment.
Yes.
A lot of digging. Do you see any?
Mr. Chairman, Commission, what we've been doing is assessing it on a monthly basis. And so I have not been rolling over performance 1 month to the next. I'm kind of saying, okay, you get to hit the reset button on the 1st of each month, and it's up to you to take corrective action this month. Well, so we have seen some get better, some get worse, and so they're probably just taking the place of one another from month to month, right? But we have been trying to work by hitting the reset button every month. And so I think the rule actually allows us to look at a 5-year performance period. And if I go back to 5 years and assess somebody a civil penalty, they're probably in the thousands, and that number is not going to be pretty either. So I don't think we're here to put people out of business. It's more to work with and ensuring compliance and trying to educate them. So that's kind of the intent and the practice that we've implemented. I think it's been effective. I mean, it's a big number across the board. It's a lot of utilities. We have probably about 650 members of the one call underground utilities, not across the board, all industry types. And so, if you divided that up, 1 month, somebody probably got hit pretty hard at the beginning and we got their attention. And so they have a downward trend now. We also have set some thresholds that says, hey, okay, look, you've taken some corrective action. If you can get me within 5, 10, 15 of your number from last month, maybe we just have a corrective action plan with no civil penalties. So it's an ongoing monitoring program as well. It's a work in progress, but we hope obviously to get better. I mean, I hope that number is 0. Oh, that's always been my goal. So on the New Mexico Excavation Law training, public outreach days, if you remember at the very beginning, that was almost 0 because we just didn't have the resources. We ended with 61 days where we actually were able to send staff out to help coach and train and educate people. And we have thus far, at the end of 24, had about 44 either individuals or alleged violators participate in a mandatory training program resulting from those 92 mandatory training letters. And so there's still some people that are going to be taking the training. But a lot of work went into 24, and especially that last 6 months, we were really busy and things ramped up for us, for the industry, for everybody. The call center, they've had about a 10% increase in the ticket volume from the year before. So that means there's a lot of excavation taking place. And with that, Commissioner, I'll stand for questions.
Great, thank you. And as always, it's a good reminder of how much activity there is out there. And then, you had the challenge of staffing up with the increase in scope, and so it's still impressive that you've done that. And now we're replacing retirees. That's also good news. I'm glad people work here and long enough they can retire. So anyway, thank you.
Yes, sir.
Any other questions?
Mr. Chair, to get myself out of trouble, I need to pass on a message, and that is, Jason, you're going to have to take me out to the field at some point in time for a multi-day inspection or show me what you do, because you know who told me that I had to say this.
Mr. Chairman, Commissioner, we have to get you through operator qualified training first. No, I'm just kidding.
If you encounter a smart pig, tell us, should we be worried that the machines have taken over?
His mother made me do that.
Oh. Well, there's.
Make sure you get my son down here.
Yeah, Mr. Chairman, Commissioners, there's definitely a lot of pipelines in the area that you represent, so we could probably make that happen relatively easy.
Thank you for the presentation. I don't have any questions for you, but just want to say thank you again for the work you do and to your team as well.
Thank you. Thank you, Commissioner.
As always, thanks.
Take care.
Okay, Nick, we have another quarterly report, this time from Consumer Relations Division, Mr. Jimenez, and looks like he's relying on some assistance here. So that's good. Okay, thank you.
Good afternoon, Commissioners. Welcome, Commissioner Nybert. My name is Ryan Jimenez. I'm the Consumer Relations Division Director. And here I have Miss Amanda Armijo. She's one of our lead compliance officers with the PRC. She's actually the backbone of CRD. Since she's been in her role, she's processed and mediated over 500 complaints, and huge asset to our team. Huge asset to the PRC and to the consumers and constituents of New Mexico. So with that, I'll go ahead and let her begin her presentation.
Good afternoon, Mr. Chairman and Commissioners. For our Q4, our complaints with the Consumers Relations Division, we were looking at 110 total utility complaints. 55, which is the majority of them, would be electrical and co-op. We are looking at 23 telecom complaints. It's not as high as our utility, but it does get up there sometimes. We got maybe about 15 gas and propane complaints. That varies throughout New Mexico, obviously. 11 water complaints and 6 cellular telephone complaints for the Q4. For our year-end totals, we are looking at 616 total utility complaints. Again, that is the majority would be our utility co-op complaints with a number of 250. We also have 83 transportation complaints, but as you know, we no longer handle the transportation complaints thanks to DOT.
I was going to ask you about that, but
we have 175 telecom complaints, 55 gas and propane complaints, and 53 cellular and internet complaints for the year.
I mean, the transportation complaints, I'd expect we're going to continue to get them as long as the regulated transportation providers still have a PRC number on their vehicle.
Yeah.
Do you have any idea if that will last forever or?
We still get phone calls in regards to the insurance issues and the Secretary of State's corporations and LLC issues. So we'll probably still be getting them for a while. We touched base with Alicia Ortiz, the director there at DOT. So we've been given a good contact to go ahead and refer these customers or these consumers, these complaints to their offices, and they're off and running with them. So we've been in touch with them also.
Okay, so it sounds like you've got a good link with them and
Yes, sir.
expect us to get transportation complaints.
Yeah.
As long as vehicles exist.
Yeah, and even sometimes we'll get complaints, people thinking that it's the PRC drivers that are actually swerving in and out of traffic or speeding or whatever it may be. So sometimes we have to educate the consumers on that aspect.
Tim.
Hey, I won't say that any
Oh,
names.
sorry.
So out of the 186 utility complaints, they were billing complaints. 52 of those complaints were outages. Weather issued, accidents, incidents, it just varies. 112 repaired delays and held orders. That's basically just for the manpower that the utilities were lacking. I believe that they are on the increase of hiring people, so that hopefully that does go down. 37 telecom complaints and the 39 electric utility complaints for the year. The total cost that we have recovered for our consumers for the Q4 is $3,720.22. That is accounts being credited, billing issues, billing corrections. It varies on that part as well. And for our year to date, we have recovered $64,406.61 for our consumers. Again, that's just coming through our complaints and our systems that we were able to help them with.
Thank you for that presentation. Are there any other questions?
Mr. Chair, when somebody contacts us with a complaint because of our role as potential adjudicators over a complaint matter, what am I supposed to do with those communications? Do I send it to you? Do I send it to general counsel? Do I send it to the cloud? What do I do if somebody calls? Yeah, what do I do when somebody calls or sends me an email or a text that reflects that they have a complaint about? If it's transportation, I'll tell them to call DOT, but that fits within our purview. What am I supposed to do?
Mr. Chair, Commissioner Nybert. So anytime you do receive a complaint or an inquiry, please refer them to us. I'll go ahead and send you all our contact information. We try to be the front lines for the PRC, especially for you all. If there's anybody that does call and complain, we have excellent contacts up there at the utilities. We do advise the consumer to go ahead and file the informal complaint through our system. That way we do get all the information and any supporting documents that may go along with the complaint, but also it gives us permission to go ahead and look into their account on their behalf. So if they have John Doe has a complaint in regards to PNM issue, then we would like something in writing from the complainant. That way we could go ahead and inquire with our executive contacts up there at PNM to obtain some information and try to assist the consumer through their issues. If there's something there that we can try to negotiate some type of resolution and obtaining some type of credits or refunds, then we could do that. But we would need the consumer to go ahead and file that complaint with us so we can go ahead and move forward to do that.
Mr. Cameron, is there anything that when I respond to an email or a text that I should say in that text or email to, other than just referring them to this department, but is there anything that I need to say or do to reflect that, ultimately we may be hearing a case that may result from that? Is there something I need to specifically put in there to reflect the unique nature that we sit in.
Yeah, Commissioner, thanks for the question. I mean, technically legally, no, but you know, I can work with you and the other, I don't know how often the commissioners get. I know you get, you know, not so much complaints, but other types of correspondence, and we deal with it on kind of a case by case basis, but I'd be happy to come up with some kind of a form, template email to send back, something along the lines of, you know, thanks for your email, and I'm going to forward this over to our CRD, and something to reflect what you were talking about, which is, you know, and this is for your information as well. I guess I was going to jump in anyways, but just so you know, the complaints always start out as an informal complaint, and as you can tell by the numbers, way more complaints get resolved informally than formally. Only after the informal complaint process doesn't come to a resolution does it, if the consumer wants to, does it become a formal complaint and end up in front of the commission. So we could come up with something, you know, kind of short, sweet, that basically kind of lets people know that. And by the same token, you could just make it even shorter and sweeter, which is, I'm going to forward this over to CRD because I know that they provide the same information basically to that person. Once they get a hold of the complaint, they inform them of the process, and it's on our website as well. So.
Yeah, I may be in a unique situation because people are used to complaining to me.
Right,
about a lot of stuff.
right.
But, you know, a lot of the Alamogordo gas issues, you know, I'm still getting stuff on that. And so I just need a little guidance to make sure that I'm
Sure.
responding to those appropriately.
Yeah. And if the commissioner would like, we could set you up as the complaint department.
Come on over.
Thanks a lot.
Come on over.
Sounds like you're a natural.
I refer to just be the conduit that gets it to where it really needs to go.
Yeah, no, that's a great question. And I would assume that as time goes on, maybe that will, as people see you in your new role, understand your new role, that will maybe diminish, but I could imagine that's
Or
going to
it
happen.
may increase.
Or it may increase, exactly, right. So I can imagine that's going to happen for a while, so, yeah.
And Mr. Chair, Commissioner Nybert, we do keep, we keep communications, we keep record of everything that we do on our end. So if there's any time that, you know, you need record of John Doe filing the complaint and what happened, or can you update me with this? We'll of course go through Scott first to see if there's anything that needs to be, you know, as far as ex parte goes, but we will have all those communications for you all if you all need that.
You got to one point that I was gonna talk about was sometimes there's a complaint about an open proceeding, and then there we have the ex parte rules, in which case we there's a different process to get that actually uploaded into the record. If it's an email, for example, or phone call.
Did you have something you wanted to add?
Thank you, Mr. Chair. Maybe I'm too formal. I stand on like being recognized over here. Yes, I did want to address this. Division Director Jimenez and Cameron and Bagatko and I have kind of been having ongoing conversations about the right process for informal, formal, something in between. So I do expect that this is an issue that will be taken up in 2025. And so for now, if our general counsel can provide the commissioners with that guidance, I also think it's something that we will be revisiting in our continual process of improving ourselves.
Yeah, thank you for that. And just something I feel compelled to add is one of the things you'll learn, I think, that helps with the situation you're in is this team is great.
Thank you, Commissioner.
Thank you.
So they are timely, they're responsive, they work for solutions. As you can see, informal complaints rarely reach formal level. So as you get more experience with that, CRD staff is a huge part of how that makes your life livable.
Thank you, Mr. Chair.
It does seem that with the number of people who no longer have landlines, that's putting some issues on the table for at least Quest in my community, and I've gotten a lot of complaints about inability to get repairs, inability to get their service restored because of lack of equipment, lack of replacement parts, lack of people to install those things. And so I think that aspect probably is going to get worse as time goes on, not better, because of the financial constraints that I think some of the landline folks are finding themselves in.
Well, great. Thank you.
Thank you, commissioners.
Thank
Great
you.
day. Welcome.
Okay,
Thank you.
Be sure to send me your.
Yes, sir. Thank you.
Next up is communications with Chief of Staff, Ms. Corey.
All right, good afternoon, commissioners. I've told 3 people now that I will get with them immediately after this meeting, so I better hurry, otherwise I'm gonna make a liar out of myself. So I love it when you hear from our stellar staff, makes my job of updating you easier. So I'm just gonna hit a couple of points. I wanna welcome a new hearing examiner. I was remiss in getting my announcement bullet on the agenda this week. And so I do want to welcome Patrick Schaefer to our hearing examiner division. We're very excited for him to join us. Feel confident that he's going to be a huge asset to the agency. So if you get a chance to say hi to him, please do, and welcome him to the PRC family. Also, I want to congratulate Janine Zertucci on her promotion. She's in our administrative services division, and she has recently been promoted to ASD fleet coordinator and fiscal agent. So congratulations to her. And then also on the personnel front, we are very close to filling quite a number of new positions, and I've been really pushing our staff so that when we go into our hearings next week, we have signed offer letters in hand, so I can announce a much lower vacancy rate than we have today. Looking forward, that is something that I'm hopeful that we will accomplish between now and Monday, because there's like a day and a half of work time, so lots of time to get that done. But thank you to everybody who's been contributing to that push. And then I highlighted it last time, our book club book this month is Dare to Lead. I want to express my gratitude to at least the executive team who were voluntold that they have to read this book and work through it in our executive staff meetings. What I'm hearing is that it's added new language to our conversations as leaders. I encourage everyone in this agency to read it. It's not about utility law. It's a quick, easy read. And I think it will help in what we're trying to do here. And that is explore new ways of improving ourselves. Whether you're a manager in this agency or not, all of us can learn leadership skills because you don't have to have the title to be a leader. And so I really hope that everyone will read it. And I look forward to the conversation that we're going to have in mid-March when we do our book review. So with those kind of highlights, I stand for any questions or other conversation that you have for me.
Well, I appreciate that I was given a copy of the book. Is there anything I should infer from the fact that it's the large print edition?
I was not aware that we ordered the large print edition, but
They were the most inexpensive ones, that's the only reason.
oh, cost savings.
Yeah, cost savings, that's good.
You always feel like you're reading faster. Anyway, looking forward to reading that, but thank you. Any other questions for Chief of Staff? All right, thank you. Okay, home stretch. This communication with commissioners is just opportunity to share with each other and the people watching what we're up to. For myself, I'm going to be tomorrow participating in a California Energy Commission workshop on regional markets. There's a panel of folks who signed the letter that then resulted in the West-wide pathway governance initiative, and so just checking in on why we did that and what's happened since then. And so the workshop runs most of the day tomorrow. You can find out, you can watch it on Zoom. And then one of the things that I'm looking forward to, I haven't seen it yet, is there's another Brattle study of how different footprints and how regional markets seem to be evolving out west, the economic implications on that. So looking forward to seeing an update from Brattle. We had a Brattle study that PNM and EPE brought in 6 months ago, 4 months ago, maybe. But anyway, I think this will be an update on it. So if you're interested, California Energy Commission webpage. Then next week, I'm going to travel to Colorado. There's a conference called Western Power Players. It's supposed to be a idea generating thing. So I've never attended that. I'm looking forward to seeing what happens there. And then finally, before we meet again, there will be a meeting on SPP's RSC Monday, February 3rd. And those meetings are all available online, and that meeting is actually online also, so I'm not going anywhere for that. I'll be calling in from the office here. There's a few voting items, and a lot of them are pointed at exactly what you were talking about, Commissioner Nybert, is the need to accelerate adding new load and new generation to the SPP system. So I'll certainly update you with anything that happens from there at our next meeting. Any other items?
Yeah, just want to quickly mention that next week I'll be on a panel put on by the British Consulate General. They're based out of Houston, and it's kind of like the regional consulates, includes Texas, New Mexico, a few other states. And that is on so that's on Tuesday at 9 o'clock at the Inn and Spa at Loretto, some conference room in there. And I think it's free for the public, so whoever is interested in signing up can do that. And on the panel will be Rita and some opening remarks by Melanie Kenderdine, or Secretary of MNERD. And then I will also be at the Western Power Players Conference next week. So it'll be a busy week.
Yeah, not looking forward to going from cold here to colder there, but we'll see. Commissioner Nybert, bring us home.
Not going anywhere other than that office to try to catch up on all the stuff you guys are sending me. So I'll be around.
Great. I tried to show you the light at the end of the
That's right.
Cape certification tunnel. It's this handsome pin. So that, and you're more ethical. So I'm looking forward to that. No, thank you. So with seeing no objection, we are adjourned.